Got a question asking about what's the eviction process with a landlord and tenant if the parties only have a verbal rental agreement and there's no written contract. Okay, the initial agreement was for 2 years. It started in January 2024. How does that work? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, to answer this question, I'm going to use California state law. Okay, if you don't have a written rental agreement, doesn't mean that you're out of the park, that you can evict a tenant for cause, particularly if they don't pay their rent. Okay, that type of deal. Okay, what the law presumes is, if under the civil code, is if you pay rent by the month, you're presumed to have a month-to-month agreement. Okay, and how you terminate that agreement is going to depend on the locality where you're at, if state law is going to apply, or a local just cause eviction ordinance is going to apply, because certain landlords are going to be subject to just cause eviction, meaning you have to meet the definition of a cause eviction. You have to evict a tenant for a certain ground, like non-payment of rent is a classic grounds. Okay, failure to give access to a landlord is another one under state law and most local ordinances. Probably gonna be hard to enforce material terms of a lease rental agreement without a written agreement, so that's probably out the door. But tenant can't cause a nuisance, so that's like, those are like the major ones. Okay, generalizing. Okay, so to answer this questioner's question, I don't know exactly. They're not very clear about if they are evicting the tenant for cause, like they're not paying their rent or anything like that. Assuming it was like for rent, that would probably be sufficient cause to do that. Okay, you don't have to have a written rental agreement to have a landlord-tenant relationship, although the joke goes, you know, an oral agreement is worth the paper that it's printed on. Okay, so there you go, type deal. It makes it a little bit harder to deal with things, but if it's something like the parties were paying rent, the tenant's not paying rent, you don't have to have a written rental agreement for that. You would show the history of payments and the intent of the parties, and usually there's evidence of that, like text messages and conversations, that type of deal, that clearly establish a landlord-tenant relationship. So mileage is going to vary. If you're a landlord with an oral rental agreement and you don't know if you can terminate a tenancy for cause or not, or what the rules are, and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.